Judgment in the matter of SFranses Limited versus the Cavendish Hotel, London Limited.
Lord Sumption will explain the judgment of the court in this case also.
Under the Landlord and Tenant Act 1954, the tenant of business premises is entitled, when his lease comes to an end, to require a new lease. If the landlord refuses, he is entitled to apply to the court for one. The Act lays down a number of grounds on which the court must refuse a new lease. One of them is that the landlord intends to demolish the premises or reconstruct them, or carry out substantial building works inconsistent with the continued occupation by the tenant. If the court concludes that these works cannot reasonably be carried out with the tenant still in possession, then it must refuse a new lease and grant vacant possession to the landlord. It is well established that the landlord's proposed works do not have to be useful, nor does the landlord's intention to carry them out have to be reasonable. It just has to be a firm and settled intention, genuinely held by the landlord. All this is settled law, and nobody is suggesting that it should be overruled. But it is open to abuse, as the facts of this remarkable case illustrate. SFranses Limited is a dealer and conserver of antique textiles with premises on the ground floor and basement of a building in Jermyn Street, St. James's. His landlord occupies the rest of the building, which it operates as a hotel. When the tenant's lease expired, the landlord resisted the tenant's application for a new tenancy on the grounds that he intended to carry out a radical internal reconstruction of the premises occupied by the tenant. The landlord admitted that his works were completely useless. They comprised such things as building internal walls which stopped short of external walls, leaving an open gap, demolishing other internal walls and then rebuilding them identically in the same place, digging out useless and dangerous steps in the floor, repositioning smoke vents for no reason, and building 2 retail shop units, one of which had no street access. The result would be commercially unusable because without corresponding external works, there would be little prospect of obtaining planning permission for any commercially useful purpose. The landlord made no secret of the fact that the sole purpose of this enterprise was to get the tenant out. They therefore had to do sufficiently extensive works to be substantial, a requirement of the Act, and they had to be sufficiently disruptive to require the removal of the tenant. The landlord has given an undertaking to the court to carry the works out, but he would not have given that undertaking or carried the works out if the tenant were to go voluntarily. All of this will cost the landlord £776,707, but such is the value of property in Jermyn Street that it will be worth spending that money just to get vacant possession. It is clear that the landlord's intention to carry them out is conditional. Conditional, that is, on their being necessary to achieve that end. The County Court judge found that the landlord's intention was entirely genuine and held that it didn't matter what its purpose was. The Court of Appeal agreed. The Supreme Court unanimously allows the appeal. The Court agrees with the courts below that the landlord's motives for wanting to carry out the works are legally irrelevant in themselves, provided that he genuinely intends to carry them out. But they may nevertheless be evidence to show that the intention of the landlord is not the kind of intention that is required by the Act. A conditional intention is not good enough to satisfy the Act. This is because of the way that the Act works according to its terms. The landlord is entitled to recover possession of the premises if he intends to carry out works which are inconsistent with the tenant's continued presence there, and the tenant's possession is accordingly an obstacle to his project. This means that the landlord's intention to carry out the works must exist independently of the tenant's presence. He must intend to carry them out, whether the tenant leaves voluntarily or under an order of the court. On the facts of this case, the landlord did not unconditionally intend to carry out the works. He did not therefore have the firm and settled intention that the Act requires. The facts of this case, as I've said, are extreme. A less extreme, but in practice much commoner variant of the facts, is the case where the landlord does genuinely intend and unconditionally intend to carry out part of the works, but artificially increases their scope in order to ensure that they are inconsistent with the tenant remaining in possession. In that case, the effect of the reasoning of this court is that the application for a new tenancy must be dealt with on the footing that only the unconditionally intended works are relevant.